Howdy, this is David Groce, your Texas Tax and Lawman. Welcome back to our real estate series, Big Hat, Big Cattle. I know this comes as no shocker, but everything we do today has risk. We have tough, smart lawyers and the Texas Hammer coming after anybody they think has money. Well, God forbid you save your money and choose to invest in real estate and become the target of these land sharks. While none of us like to think about these vultures sitting on a power line waiting to sweep in and gobble us up, prudent planning says that we know and manage our business risk. Let's hit the top 3 liability concerns that you should have as a landlord. First, the Fair Housing Act. In 1968, the Fair Housing Act became law and prohibits discriminatory practices by landlords. I know this seems obvious to us 51 years later, but as a landlord, you cannot discriminate against a tenant based on their race, color, national origin, religion, sex, marital status, or disability. When you are leasing or advertising your property, make your application criteria sufficiently strong to protect your interests. Require a credit check, a significant deposit, and a detailed application. Then, do your homework. Call the references and past landlords and find out how these prospective tenants do business. Then, you can turn them down based on being a bad risk, not based on a discriminatory reason. But even better, when you properly vet your tenants, you get people who are solid, reliable, and pay their rent. Second, land occupier liability. This is a fancy legal term that means you are responsible for what happens on your land. As the landlord, you have certain duties to provide what you represent, a clean and maintained place to live. While you can control who lives in your property, you will not always know all the guests and invitees who come onto your property. You protect yourself by having a good general liability and property damage insurance. And you should require each tenant to maintain tenant insurance as well that insures you against their negligent acts and insures their personal property inside the rental in the case of a fire or loss. Third, contractual liability. This may seem obvious, but let me say it clearly. Every tenant should sign a written lease before you move them into your rental. In Texas, like most states, we have a statute of frauds that requires certain types of agreement to be in writing. The biggest one is contracts regarding land. Do not move someone into your property without having them sign a written lease that defines the key terms like the length of the lease payment, when rent is due, the tenant responsibilities, and termination. If you need help with these issues, give us a call. We regularly help clients manage and limit their risk exposure through proper legal structure and recommending the proper insurance protections. That way, we leave the vultures sitting on the tree looking for someone else to eat. Until next time, adios. Texas Tax and Lawman legal disclaimer. Hey, I'm a lawyer. You know I have to have some lawyer mumbo jumbo. This is a general information video, not client attorney privilege information. The content is information only and is not directed to any specific facts or circumstances and cannot be relied upon as a legal opinion, even though that would be nice and save you a trip to the lawyer. If you have a specific legal question, feel free to contact David Groce directly or seek qualified legal or tax counsel in your state of residence, state of mind, or whatever place you call home.